suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is in the building and sitting on the chair here at our studio at ABC Radio Melbourne. Mornings. David Whiting, good morning.
Good morning, Virginia.
We had an interesting challenge to you, which the alacrity in your voice with which you immediately said, oh, I'll take that as homework because there's been a decision in VCAT that influences this. And I got excited thinking, do we now have an established precedent for what to do with refunds that were not given because of banned or cancelled COVID travel?
Caitlin was the last caller last week, and Caitlin was talking about a $20,000 trip that Mum and Dad were going to take to Alaska and Canada, and they'd been offered a credit. And to date, there's only been one decision in Victoria that's been reported that deals with frustration.
That issue. Frustration.
And there's a section in the Australian Consumer Law and Fair Trading Act which says that talks about performance of a contract becoming impossible or the contract being otherwise frustrated.
I just have this image of a contract sitting there going, oh, just feeling terribly frustrated.
Oh, is that right? Okay.
Go on.
I'll drop off some legal textbooks for you to help you get over that problem.
Look, I'm just trying to illustrate what you're saying, but all right, go on.
Well, there's a case decided in the middle of March called Beresford and A&J McKenzie, and it involved a hire of a houseboat on the Murray, which is technically New South Wales. Mm-hmm. And a person in Melbourne got together with a person in Queensland, and they agreed that together they would hire this boat. So there were a number of them going, and what happened was there were lockdown laws in Victoria and in Queensland that prevented travel. And so having paid $1,900 to the people who owned the boat, they've gone to VCAT and said, we'd like the money back, please. And they had argued that the contract was frustrated. And the member at VCAT...
A bit of water for you?
No,
I think we might need a bit of water.
The member at VCAT said that because of the lockdown laws, the contract was not capable of the contract was impossible, and therefore you can get your money back, which I think, with due respect to the member at VCAT, is wrong. Because
they get to decide
when we're talking about frustration, we're talking about frustration being it's not capable of being performed. And I'm saying the houseboat was still there, it was still available for rent. They weren't able to get there, but that was a rule which was affecting them.
So if you're saying that you think VCAT has got it wrong, what happens?
Well, I feel very sorry for the people who own the hire boats on the Murray, because the way to dispute a matter at VCAT is to issue a claim in the Supreme Court on a question of law. And for the $1,900 involved in the hiring fee, you wouldn't go anywhere near it because you'd be spending probably 10 or 15 times that to argue the question.
So what does this all amount to for our caller?
Well, I think if you were going to run a VCAT argument, then you can come along and say, well, there's already a decision here at VCAT which says here's a decision by this tribunal which made this finding on similar facts, and therefore I would like to get a refund, please. But discussing it with someone at work this morning, they told me a story of a man who tried to claim on his superannuation on the basis that he was physically incapable of performing work. And he'd actually been locked up, so he was in prison, couldn't attend his place of work. So his argument was he should be able to get his superannuation because he was unable to work. Distinguish, if you will, between unable to attend the place of work and being unable to perform the work.
Yes, yes.
So if you come back to this particular one, the hirer of the boat was unable. I've got all sympathy in the world for the hirer, but I've also got sympathy for the owner.
Okay, there you go. So not quite the great outcome I guess we were hoping for there. No. Let's take your calls, 1300 222 774. We're going to start with a fencing dispute because they always intrigue me. Good morning, Brian.
Good morning, Virginia and David. Calling on behalf of my mother, who lives next door to a tenanted property, and on Sunday she suddenly found during the day that a whole lot of fencing timber had been deposited on her front lawn, and then a contractor turned up during the day and started to work on the fence and told her to use her power and told her that she would have to pay half of this fence that was going to be rebuilt. And she knows nothing about it and hasn't been approached. So I just wonder where she stands as far as does she actually have an obligation to pay if she hasn't been approached regarding this?
The starting proposition under the Fences Act is that you try and get an agreement, and if you can't get an agreement, you go to court asking for a contribution, and you ask for the court to make the contribution. There's also another provision in the Fences Act which says it's an offence to start building the fence without either the agreement of the owner or a court order. So my view would be at the time that your neighbour started this process, there's no longer a need for a fence, so I'm not going to contribute. If I was your mum, I'd make a value judgment at the end. Am I prepared to contribute, and if so, how much? Did the fence really need replacing? How much longer? What life did it have in it? All sorts of things like that. I don't believe your mother has an obligation to contribute to the fence if it's constructed before there's an agreement in place.
Who's the authority involved in this? Is it Disputes Resolution Victoria?
You can take them at a Dispute Resolution Victoria, but they're not trying to determine people's rights. They try and reach an accommodation between your mum and the neighbour or the owner of the property next door, because fencing is an owner-owner obligation, not an occupier obligation.
Right.
So you could go to, but my preference would be that you let the other side do the running.
Just wait and let them...
let them work it out, because the fencer can't get any money from your mum. Your mum's got no agreement with the fencer.
And so no obligation. So we hope that ends well for you. Thank you for calling in. Ian in Hawthorn, good morning.
Oh, good morning. My partner has just decided to sell an apartment she owns in a large apartment block. And it's during the process discovered that is one of the buildings nominated with flammable cladding.
Yes.
Now, we are just wondering, what are the obligations in terms of the body corporate of the block are currently going through a scope of works to determine the cost and the extent of what has to be done. But what are the obligations on apartment owners in this case to pay for restitution, or if she now tries to sell it?
I've got one at the moment, Ian, where I'm acting for someone in exactly the same situation.
Okay.
And there's an obligation. Sorry, the first thing is that under the Owners Corporation Act, if you're selling an apartment or a unit, you've got to give a whole lot of information to a buyer. That includes generally the last annual general meeting records. And I would have thought in the annual general meeting records there would be a notation about cladding. There may even be a report as to what's happened or what's proposed. That's the first one. The second is that under Section 12 of the Sale of Land Act, you are required to tell a buyer if you think that there's anything that a buyer would reasonably want to know when making a decision to buy your property.
Okay. So an obligation to disclose.
In a sense, it's a one-liner.
Yep.
That says the building's on the register because it has flammable cladding, and that it's being invested. The full extent of the work required is being investigated by the Owners Corporation.
Okay, so an obligation to disclose that.
Yes.
So just be straightforward and clear. Thanks for calling in, Michael in Maryborough. What's happening?
Oh, good morning. We've got a B&B or a bed and breakfast on our farm in central Victoria. About 400 metres away is our principal place of residence, where we've got a swimming pool. And we're thinking of renting out the pool on an hourly basis if any guests of the bed and breakfast should so wish to use it. Are we opening ourselves up to any potential legal situations by doing that?
I would have thought so, yes. But okay. I think it's more from the use than the fee.
Yep.
So you'd need to make sure it's appropriately fenced. You might include some conditions as to how, whether children can be supervised or not supervised.
Right.
So I don't say that they're because of the fee. I think it's because you're allowing people to use it.
Okay. Thank you.
Thank you.
All right. Thanks for calling in. Ken in Croydon, what's happening?
Oh, good. Thanks for speaking to me. My wife's brother is in hospital. He's not able to sign a power of attorney, how do we get authority to pay his bills and sell his unit and also medical, because he's not able to sign anything?
Ken, is it possible that he could give someone instructions to sign the power of attorney on his behalf?
Not really. He can't even peel a banana. He's totally...
No. There's two parts to the question, right?
Right.
It is, if it's, you don't see it often, but you do, if someone is incapable of signing but capable of instructing someone else to sign,
Right.
then the power of attorney could be signed on behalf of the person giving the power.
Oh, right.
Now,
right.
there are a couple of hoops you need to jump through.
Right.
There can't be a care provider. It can't be a relative of the attorney. But if you have a good friend of your brother-in-law, I think it was, who would be able to sign the power of attorney on the basis of instructions. Yeah, good friend. On the basis, there's no qualification for this person.
Okay.
Right. Now, this is the second part. If he can eventually sign, if he gets better, we're just confused with who can we get to witness the signature? Do we go and get a police divvy van and get the policeman to come to the hospital?
In order to witness a power of attorney, the witnessing needs to be done by a person who can administer an oath in Victoria, take an affidavit.
And I've got a big list here, but how do you actually get them to the hospital?
You beg. Or you pay, one or the other.
To go.
Yes.
All right. Well, look, good luck with that. We hope that's helpful. We've got another power of attorney question, so let's bracket those together. Justin in Clifton Hill, hello.
Hi, David and Virginia. Look, I hold a power of attorney with my sister for financial matters and for my parents. They're in their 90s, living in their own home still. I separately hold powers of attorney for health issues. My sister has raised the prospect of making a bid when the time comes, when Mum and Dad die, for the family home, which is a beach house. And I'm just wondering how we, and more particularly she, would fulfil those obligations without being in breach of her power of attorney and just put the obligations under the power ahead of her own.
Justin, when your mum and dad die, the power of attorney is of no effect. It ceases to be useful. So the power of attorney is not the problem. If your sister is appointed as an executor and takes on that role, so gets a grant of probate, then she would only be able to bid for the property with either the leave of the court or the consent of the beneficiaries. Okay. Right? So if it's you and her, and you say, yes, we're both the executors, I don't want you to bid for the property because, well, that's not fair, whatever reason you give, she can't, without the approval of the court, and it would be reluctant to give that approval. So on the other hand, if she is but a beneficiary, so she doesn't get a grant of probate, there is nothing to prevent her bidding for the property.
Okay.
All right. Good luck.
And in your experience, David, are those sort of processes always better by auction or negotiation?
There's a lot depends. My experience is that different suburbs or towns have different processes. Recently sold a property in a country town for an estate, and all the advice we got from all of the agents was in this part of the world it's private sale, not auction. Okay, so maybe check in with a couple of real estate agents and get the good oil on that. Thanks for calling in. Joan in Morwell, what's going on?
Hi, good morning. Look, my daughter has, along with her classmates, we signed up 18 months ago for an ecotourism trip via the school. The contract's not with the school, it's with the tourist company. Yep. To go to a third world country. And the kids spend 6 weeks there, working in the village, helping to, do all that environmentally aware, socially conscious stuff, which is great. The trip's been postponed 3 times. There's 30 of us that have paid $2,000 deposit each just in our school. And I'm making the argument that she was at the end of year 10 when this trip was going to happen. She will now be the end of this year, if it goes ahead, because it's third world country, so I can't see it happening personally. But if it goes ahead, she'll be leaving for university. She's in a completely different place in her life. It's not the trip that we signed up for, but the company point blank refuses to negotiate in any way.
Joan, you're a perfect person to have a look at Beresford and Mackenzie. It's a VCAT decision that you can find on Austli, austli.edu.au. But you need to sit down with the terms and conditions of the arrangement that was entered into.
So say again the name of the matter?
The matter. Beresford, Beresford, and A&J Mackenzie.
Beresford and A&J Mackenzie
Proprietary Limited.
On
and
Austli.
It's March 2021. But when you look at it, Joan, you need to look at the terms and conditions of the tour.
All right. Yeah. So have a look at that closely.
I guess that's part of the problem, because they're saying, that there's no refund.
Well, Joan, I do have some sympathy for the operator. The money that you've paid may have been used to pay forward deposits and all sorts of things. So you need to have a read of the frustration provisions, Australian Consumer Law and Fair Trading Act, Victorian legislation, Section 35, and also have a look at that Beresford decision. Just get for a better feel of what your argument is.
Good to hear from you. Thank you. Anne in Kyabram, good morning.
Good morning. Good morning. My question's similar. We also had booked into a large fair in Melbourne, which didn't eventuate. They had to cancel it twice. We've been hassling for a refund, and they sent us half the deposit back last week. How do we get the rest back, or is it illegal or not?
Well, you could take the matter to VCAT. What were their terms and conditions? Presumably, they weren't allowed.
We were told we'd lose $300, which we were fine with.
Yes.
But then they took over $1,000.
More.
Mm-hmm.
And you need to look and see what the deal is. But I would have thought that you were a perfect case for frustration, because they wouldn't have been able to operate the venue.
No, they still haven't.
No, because they can't operate. Part of my argument about frustration is that the subject matter, the hall hire couldn't proceed, which would be different from Anne can't get from Kai to Melbourne.
Oh, no, we were prepared to go. But
no, I know, but the case we've talked about, Beresford, is about someone who couldn't get to the Murray River to get on the boat. You were in a situation where you could drive from Kyabram to Melbourne,
yes.
But the hall couldn't be opened for you.
No.
And I say that's the real essence of the frustrating event.
So what should she do?
I would be writing to them and say, you weren't able to hold a function, I want my money back.
Yeah, that's right, because it was through no fault of your own. Patricia in Toorak, what's happening there?
Good morning, and thank you, and good morning, everybody. My query is, how does one persuade the Owners Corporation to keep common property in good repair? There is, for example, just one example, there's a downpipe leaking near the front foyer, and there's green slime on the footpath there, and my crutches won't get any traction. And I am beginning to feel very unsafe in my own home.
Well, that's unacceptable. What should she do?
Well, it's a common property. She owns this area in conjunction with other people, and that's your problem. Patricia, you need to persuade them that it's in everybody's interest to spend the money to achieve the outcome. How old is the building, Patricia?
It started construction in 1956.
Okay, so it's a 60-year-old building. Okay.
Yeah.
I was just wondering whether or not there might be some kind of claim against the builder in terms of drainage, but at that point, no.
Have you spoken to them about it, Patricia, and asked them to do something?
I have emailed them and been told that I should come to committee meetings, and because they're all working full time, I should come to committee meetings and report it. And I can't get to committee meetings because it's 2 trams at 6 p.m, etc., etc. And at the moment, I can hardly walk.
So, Patricia, why would you not put a note under everybody's door and say, "Here's my..."
There are 49 doors, and I am not capable of walking around 3 flights of stairs.
Well, then just do one floor. It's a question. What you've got to do is persuade the.
Why does she have to persuade? If they're all joint owners, why does that have to be persuaded? If one person says this is a key safety problem, let's sort it.
And the other 58 shrug.
The other 38.
The other 38 come along and say, well, we don't think it's as bad as you make it out to be. We're not doing anything about it.
Well, if they're not disabled, they probably don't see it as a problem.
I understand that, but you live in an environment where 38 other people have the same number of votes as you do, and you need to get the right number of people on side for your view to hold sway.
Get them to Zoom you into the meeting, Patricia. You could maybe, could you appear by phone at the meeting?
No, don't talk to me about Zoom, please.
That's why I changed it to phone.
And listen, we also do have a paid manager, and I've reported things to him, and nothing happens.
Oh, well, that's ridiculous. The manager should be doing something about it, surely, David.
The manager should, but the manager administers the plan adopted by the committee.
Yes, I get that, but it's just more about being reasonable here. For
you
goodness
can
sake.
be reasonable and see it my way, or reasonable and see it the collective way. There is a process for going to VCAT.
Collective safety is a thing.
But getting to VCAT would be much harder for Patricia than getting to the meeting.
Okay, we don't have a solution for Patricia. What do you say that she do?
I think she needs to get someone else to put the notes under everybody else's door.
Can someone help you there, Patricia?
I doubt it.
Oh, dear.
Well, give it a go.
Maybe see if there's someone you could speak to, a friend or a colleague or a family member you could lean on who could maybe even take your proxy and appear on Patricia's behalf at the meeting.
Yes, that would work.
Patricia, if you could maybe do that, if there's one person in your life or maybe one friend or friendly person you have in the building who might take your proxy to the meeting and appear and make the argument about safety. And Patricia, stay in touch.
Meeting?
Sorry?
The committee meeting?
Yeah.
I tell you what happens, I put an item on the agenda and it comes up in the minutes as my item's on the agenda and it says Patricia was not here to speak to this.
No, I was saying get someone to appear on your behalf at the committee meeting.
I would if I could.
Well, I'm sorry if we can't help you, Patricia, but if you have a reflection and think about anyone in the building who feels the same way, one person, or as I say, a friend or a colleague or a family member who might go on your behalf, and if you get some success, let us know. But I'm sorry to hear that you feel unsafe in your own building. David, we don't have any homework there, do we?
No.
You're free and clear to go.
Thank you very much.
David Whiting, who helps you as much as he can with legal problems each week.